Hey everyone, I'm acting with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is filing a motion to re-argue and the impact that has on the appeal period in Connecticut. So basically, you file a motion to re-argue when you're not happy with the judge's decision. You can just appeal the case, which means you take it to a higher court and ask that they overturn the judge's decision. But before you do that, you're likely going to want to file a motion to re-argue to try to get the judge who made the decision change his or her mind based on the fact that they interpreted the law incorrectly or made a mistake in their decision. So that's probably the first step that you're going to want to take. So let me share some practice book sections with you to talk about the relevant statutes and whatnot. So we're first going to look at the time you have to appeal a case. So again, before you file an appeal to a higher court, you may want to file a motion to re-argue. Now, it's very important that you file that motion to re-argue within the appeal period, which, as you can see from Practice Book 63-1, Section 63-1, you basically have 20 days from the time of the judgment to file an appeal. So you want to within those 20 days file your motion to re-argue, and that basically restarts the appeal period. As soon as you file a motion to re-argue, it'll initially suspend the appeal period. And so we'll look at that section. So how a new appeal period is created. If a motion is filed within the appeal period that, if granted, would render the judgment, decision, or acceptance of the verdict ineffective, which a motion to re-argue does cover that. So if that motion is filed within 20 days, either a new 20-day period or applicable statutory time period. So basically, a new 20-day time period for filing the appeal shall begin on the day that notice of the ruling is given on the last such outstanding motion. So you have 20 days to file an appeal. So therefore, within that 20 days, you have to file your motion to re-argue. And then when you get the judge's decision on that motion to re-argue, whether it's granted or denied, at that point, when the judge issues the decision on the motion to re-argue, at that point, a new appeal period begins, which is another 20 days. So that's the timing impact of a motion to re-argue and the timing within which you have to file it. And then it goes on to say that motions that, if granted, would render a judgment, decision, or acceptance of the verdict ineffective, include but are not limited to motions to seek the opening or setting aside of a judgment, re-argument of the judgment or decision. So it's basically saying that a motion to re-argue is an example of a motion that would begin a new appeal period. And then specifically, motions that do not give rise to a new appeal period include those that seek clarification or articulation of a motion. So you need to be careful. Sometimes you'll file a motion for clarification. So a judge might issue a decision and you're not sure you fully understand it. If this is a case that you're potentially going to want to appeal down the road, you need to make sure you file a motion to re-argue, because if you only file a motion for clarification because you don't understand something, and then you get that clarification from the judge beyond the 20-day appeal period, and you don't like the result of that clarification from the judge, you have blown the appeal period if you haven't also filed the motion to re-argue. So you need to be careful around the timing on filing those motions. And then, so that was Practice Book Section 63-1. And looking at Practice Book Section 1111, this basically says motions which delay the commencement of the appeal period or cause the appeal period to start again. So it says any motions which would, sorry, you might hear my dog's making some noise over here. But any motions which would, pursuant to Section 63-1, which is the practice book section we just went over, delay the commencement of the appeal period, and any motions which would, pursuant to section 63-1, toll the appeal period and cause it to begin again, which is a motion to re-argue, shall be filed simultaneously insofar as such filing is possible, and shall be considered by the judge who rendered the underlying judgment or decision. So obviously, if you file a motion to re-argue, the judge who issued the decision needs to be the person who's hearing that motion to re-argue or ruling on it. The party filing any such motion shall set forth the judgment or decision which is the subject of the motion. You have to include in the motion the name of the judge who rendered it, the specific grounds upon which the party relies, and you shall indicate on the bottom of the first page of the motion that the motion is a section 11-11 motion. And I'll show you a sample that shows where you put that. And that this applies to, so that's pretty much the relevant language of that section. So let me go on to show you a sample motion to, this is a plaintiff's motion for reconsideration and re-argument post-judgment. So you just put that, this would be plaintiff. The plaintiff in the above captioned matter respectfully moves the court, and then you want to again include the judge's name, to re-argue and reconsider the judgment dated, whatever the date of the judgment is, and you want to include the pleading number. And you want to include the specific motion. So you list the motion to modify alimony, motion for contempt, whatever the motions were that you are unhappy with the decision. And then in support of the motion, the plaintiff respectfully represents as follows, and then you need to explain why you're seeking re-argument. And we're not going to get into that. There's any number of reasons you may be seeking re-argument, but you have to include the basis for why you're seeking that re-argument in your actual motion. And then after you include your legal argument, you just say that based on that, the defendant moves that the court reconsider the order, and again include the date of the order and the pleading number, and permit re-argument with respect to the motions and include the actual motions. So that's the sample language you're going to want to use. So that motion gets filed within 20 days, and then the judge can basically do one of two things. The judge, what will often happen is a judge will just deny your motion to re-argue, and you don't get an opportunity to be heard. They don't necessarily have to schedule these motions for a hearing. It can just be denied, at which point the appeal period begins again, that 20-day appeal period, and you make a decision as to whether or not you want to appeal the case. What a judge can also do is schedule it for a hearing. So they can, take your motion to re-argue, put it down for a hearing. You have legal argument as to, re-arguing your case, and then the judge will either change their decision or keep their decision how it is. But they will at that point either grant or deny your motion. And then if a hearing is scheduled, once the judge issues their decision following the hearing, that is the point at which the appeal period begins, if a hearing is assigned. And then again, you have an opportunity to, you have to make a decision as to whether or not you're going to want to file your appeal. So those are the basics on kind of the logistics around a motion to re-argue and the appeal period in a family law case. If you have any questions, as always, feel free to give our office a call. Take care.